Good afternoon, ladies and gentlemen. Good afternoon. How are you? A warm welcome to all of you and to everybody who's watching us live at this point. My name is Ms. Prasad and I'm your lecturer for Unit 1 of Edu Studies 2. Okay, so I'll be taking you for the legal policy section. And if you have any questions, please feel free to ask me. You can do so after this lecture. Right. Thank you. Just to remind you, we do have colleagues joining us live and at other campuses as well. So, how many of you have any sort of a legal background? Okay. So, you will feel comfortable in class or you might get bored, right? For the rest of you, if you are a bit nervous, when people hear of legal stuff, they'll be like, oh, this is a lot. What do we expect? It could be boring. I promise to make this as pain-free as possible for you, right? And by the time we finish, all those Latin terms that you need to learn and stuff, I'll put it up as a glossary for you, okay? So you don't have to memorize them. Right. Just to begin with, before we can actually start with the outcome of today's lecture, I just want to take you through the assessment tasks for this module and how you would be evaluated. So there are 2 tests. Because this is a year module, you'll have a test in the first half of the year and another one in the second half. You'll have 2 assignments, 2 online tasks, and your examination. Okay. In terms of your online task, the unit that we would start with from today would be covered in your online tasks and in test 1, but not in your assignment. Okay, it would also form a question in your exam. Right? Are there any questions on this? Yes. Okay, so you need to keep an eye on your ECI page, please, on this ECI page, and you will have the dates populated in there. You will get a reminder on your ECI calendar, right? And you will see activities and stuff ahead of time to help you with that assignment. So do not feel stressed at this point. It would not be like the day before that it's due. Okay. Any questions from our colleagues at the other campuses? No. Okay. So the outcome of today's lecture, I thought that before we can actually dive into the policies, which some people might feel very dry, maybe we can look at the history of the South African law. Not too much, but just to give you an idea how we came to the policies, okay? And then we'll actually start with the policies. So the history of the South African law is actually founded on these 2 types of law, on Roman Dutch law and the English law. Okay, your Roman Dutch law is where you get all your Latin terms from. Your English law is where most of the procedures in law comes from. Okay, when I'm talking about procedures, I'm talking about, you know, your findings for evidence, your court procedures, that is where it comes from, your English law. Whereas your Roman Dutch law, that forms more of your family law, your property law, your contracts, okay? So at this point, most of you may be asking, we are future educators. Why do we need to know the law, or how does this fit in? I think the law is extremely important. I may sound biased, but at this point, because the rights of children are glorified and the Constitution recognizes the rights of children as one of the more important rights, knowing the law is of utmost importance for educators. It can save you from the trouble in the future if you know your rights and your duties. Okay, so moving on to the Roman Dutch law, it is a combination of Roman and Dutch Germanic law, and it existed in the Netherlands from the 15th to the 19th century. It was then brought to South Africa by the Dutch colonists to the Cape of Good Hope. I know this reminds you of your history lectures, right? Your history lessons back in the day. So it was brought to the Cape of Good Hope, and that is how it became established in South Africa, right? Your Roman Dutch law forms the basis for what we call your common law, right? So then, what is the difference between your Roman Dutch law and the common law? The Roman Dutch law and common law is basically one and the same thing. The difference is that some aspects of the Roman law became codified, and these terms codified, I'll explain to you. And your common law is uncodified. When I speak of codified and uncodified, I'm actually referring to some law is actually put down on paper. Okay, if you take a look at some of the libraries or law libraries, now everything's up online, you actually find legislation in bundles, in years, and some of it dates back right up until the 1600s. If you have an interest for things like that, it's extremely interesting, right? Some people may find that boring, but your uncodified law then is all of that law that is not put into paper. Okay. So how do we know that then is the law if it's uncodified? I'll give you an example. Think back to certain things that we take for granted as common sense. Are there any examples that you make it's common sense that everybody just knows? Anybody? An example of something that we just take randomly, we assume that everybody knows? What do we think that everybody knows? We just take it for granted. Oh no, that's how it is. How about discipline? Right? As an educator or as a parent, automatically it's an assumption that a student or a learner at school should have discipline. Right? Now it's put down into paper, but back then and before it could become legislation, it was uncodified. Right? And where did that come from? Your Roman Dutch law. Okay? So a lot of stuff like your legal rights or stuff that you know legally, that you just feel, okay, no, you heard it through the grapevine, or it just exists how it exists. It's because of your Roman Dutch law. That's the common law. Right? So common law is basically uncodified. It's not promulgated. It's not enacted by parliament, but it comes through custom and culture. The custom here we're talking about is your Roman Dutch custom. There is a big difference between your common law and your customary law. So do not confuse that. I will explain the hierarchy of the law just now, but I'm just making you familiar with your common law now. Why it is so important for you to know about the common law and why I'm going on about it is because this forms the basis for your education law, especially in South Africa, right? As you can see, even though it's not codified, subsections 39 and 2 and 3 of the Constitution acknowledges that it does have a place, it does have importance, but it must be in line with the Constitution. Right? So the common law continued. Any law or developing customary law as well, so your common law and customary law must be in line with the Constitution, right? If it is not in line with the Constitution, it can be challenged. Now, this is a very, it's a very conflictual aspect because a lot of people then, when you talk about customary law, you're looking at your religious rights as well, right? So there's a lot of arguments around this, and a lot of times this has been in the media where it's challenged. Your customary rights have been challenged against the constitutional law. I'm not going to get into that now, but it's a nice topic for debate. Maybe I'll put that up as one of your forums on your ECI page, where you can share your thoughts on that, right? The BR here, I'm referring to the Bill of Rights, which is extremely important. It's one of the most important pieces of legislation in our country. And this acknowledges the existence of any rights, okay? So your common law is then different from legislation. I know it might take you some time to get used to some of these terms, but your common law is different from legislation because your legislation is written down, it's put on paper, okay? And it has that power. It has the power higher than the common law. So some of the terms, as I said, you will see some Latin terms. In a test situation or exam situation, unfortunately, you would be expected to know the Latin terms, but in your glossary, I'll put all of this up with the meaning next to it, okay? So why it is so important, the common law, why it is so important in education law is because, as you can see here, it looks at the validity of managerial or administrative acts. Now it sounds so much, such a mouthful, but it's basically saying we're referring to the tasks that certain entities at school has to perform. When I'm talking about entities, I'm looking at the school principal, okay? So there's certain acts that a school principal cannot perform. For example, the school principal cannot dismiss an educator. Okay, if he does this, he will be acting ultra virus, beyond his legal authority. Who has the right to dismiss the educator from school? Pardon? School governing body? Anybody else? Department of Education? Our colleagues in other learning centers? Okay, so the head of department, right? You were correct, ma'am. The head of department, right? Do not get confused. You'll see in some notes or in some legislation, they refer to the head of department as the HOD, right? They are not referring to the HOD in the school. They're referring to the head of department as in the head of department in the Minister of Education, okay? So it's not the head of department at the school. Okay, so my example here was if the principal, the school principal acts beyond his legal authority, he will be acting ultra virus. Hence, this common law principle is important. Then your rules of natural justice. Is my pace okay? Am I moving too quickly? Are you good? Everybody? Right, your rules of natural justice. This is another common law principles. Now remember, there's a lot of common law principles. I just picked the few that would be important to you pertaining to education law. The aim of the rules of natural justice are to ensure that justice prevails between the subjects and state. Who are the subjects we are referring to here? In a school environment. Now, everything that I'm talking about, link it to a school environment, okay? Who are the subjects in the school environment? Yes, ma'am. Yes. 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 Exactly. Correct. Okay. Even the parents, right? So those are the entities or the subjects in the school environment, and then obviously the state. So what we are trying to say here is that the common law principles exist to ensure that there's justice between all those subjects that we just mentioned and the state, okay? So both sides have a legal duty and a legal right. I'll go much deeper into that just now, but for now, that's what we're referring to as your subjects. Okay, so you see here your two principles, audi altrum partem, to hear the other side of the story, and nemo ixten propria or your sua causa. You can never be the judge in your own case. So for example, I'm sure most of you are, you have an idea about the term mediator or mediation, right? Basically, most of you are in the working world, so you know about that. If there's a problem, you do not allow the person to sit in on their own problem and be the judge of the case. You bring in a third party who's objective to the case, and they decide, okay? The same applies here. A good example of this would be if you're in a classroom and there's a problem between a teacher and a student, okay? Would the teacher then, would it be right for the teacher only to be sitting in on that matter and deciding what the outcome of the matter is? No. There would have to be a third party who's objective on the matter coming in. Right. The biggest concept or the most important concept that you'd need to know from the common law is this principle of Geborgenheid. Why? because this is the foundation of education law. So when we talk about education law, this is the foundation of it. Why? Because it literally translates into a place of safety and security. This is the reference for it. And why education law is founded on this? If you look at it firstly, there's two parts to it. It has a psychological connotation of a school environment being a place of safety and security, and then obviously a legal implication as well, right? So by the fact that it's a legal implication, it means that the school has a duty to ensure that the learners are safe and secure. Okay. This now opens up the can to all your issues of bullying or how your educators respond to students or anything that happens within the premises of the school, right? This is the foundation of education law. This is the main concept. Right, so that was your Roman Dutch law, that was your common law. Now we're looking at your English law. Now I have the date there, 1910, but that is not the date that it came into South Africa. It came in previously, but that is the date that the union was formed in South Africa in 1910. What do I mean that the union was formed? It means that the English law now prevailed. Okay, so remember, prior to that, initially in Africa, in South Africa, we had customary law only. Then in the 1600s, the Dutch brought in the Roman Dutch law. Okay, that's the timeline. Afterwards, the English brought in the English law. Then there was an entire conflict about which law prevails. And for a period of time, the English law prevailed. From the time of the entire union that was formed and all of that, right? And then what happened? It was actually where they used to have a jury. So if there were cases, you know how you watch on TV, all your favorite shows, how you see a jury? That used to actually exist in South Africa. Yes, the people with all the funny get up and all of that. And then what happened afterwards? When the next parliament took over, the jury system was abolished in 1969. And now currently in South Africa, there is no jury, as you know. There's no jury that sits in on the side. In 1961, when South Africa became a republic, that is when the English law was then amalgamated with the Roman Dutch law as well. Okay. So these dates are important. I see some of you are making notes, which is excellent. If you missed that, I will put it up on your glossary or a timeline for you if you would like. Yes? Okay. Okay, so that is how the English law came in. So currently in South Africa, we have our modern South African law is based on both the Roman Dutch law and your English law. Okay. So your big question is, how does this then fit in with policies? I took you from there to here. How does it fit in with policies? The module is looking at policies in education. Okay. Right. So this is the hierarchy of the law. At the top, you can see the Constitution, then the legislation, then your common law, then your case law, your rules and regulations, and then your policies. Okay. The Constitution is at the top, obviously, because it is the highest law of the land, as in nothing else can go against the Constitution. All the other blocks that you see below, all comes after the Constitution. If any of that is in conflict with any part of the Constitution, it can be challenged. Okay? So what you need to know for the Constitution, sections 28 and 29 are important for you. 28 and 29. 28 refers to the rights of children. Okay? And 28 basically says that is section 28 of the Constitution refers to the rights of children, and it basically speaks to the rights of children are of utmost importance. Okay? And everything has to be done in the best interests of the child. So even if a court is deciding on a matter, I'm sure most of you understand or you know about family advocates, right? That is their role, to ensure the best interest of the child. So hence, in a school situation, despite whoever has what to say, whether it's the principal or the teacher or the parent, ultimately, the outcome will be based on the best interest of the child. Okay? And then section 29 is the section that deals with education. When we look at the policies in specific, you will see how it looks at education, how learners cannot be refused admission, all of that. We will look into, at each policy in depth. Right, so below the Constitution, so always remember that's at the highest point. So this could actually make for a nice MCQ, a multiple choice question. Okay, identify the highest law, or I could ask you on the sections of the Constitution 28 to 29. Remember, I cannot test you on something that I did not teach you about. Okay, so if I did not point it out to you, I just mentioned 28 and 29, or you saw other sections 39 on here, I cannot ask you about something else. Okay, then your legislation. Your legislation is basically your acts, all your acts. Another name or another term for your legislation is statutes, right? So your acts or your statutes. That is basically your South African Schools Act and every act that you hear. That's your legislation. And then the common law, we went through that. What about your case law? All right, so when I talk about case law, I'm referring to there are some cases that were historical that marked a revolution and challenged the Constitution to an extent, which brought about new laws. I'll give you one at the top of my head. There's a case called the Grootboom case, okay? It does not pertain to education, but it's an historical case that I'm thinking at the top of my head. It deals with property, okay? That brought about the revolution, how important property is, okay? And your right to property cannot be taken away. That was one case. There's another case, micro primary school case. I will put that case up for you, or maybe a summary of that case up for you on ECI, okay? Micro primary school, the case of that dealt with language, the language policy, and that marked an historical moment for case law, for the law in South Africa. It brought about a change, okay? So your case law, what happens is, if a case was heard in a court that is a high court, for example, your high court, your Supreme Court of Appeal, or your Constitutional Court, okay, I think that was a sign from the universe that we needed a break, a breather. Right, so as I was saying, your case law, I'm not going to go too much into the courts because that could take an entire lecture, but all you need to know is as the Constitution is the highest, the Constitutional Court is the highest, okay? That has a ruling over other courts. Below that is your Supreme Court of Appeal. Below that is your High Court, and then you get your regional courts and your magistrate courts. And, right. But a court that is higher has a binding. When I say binding, I mean the outcome from that can help to form the outcome from a court that is lower. So if there was a case in the High Court or the Supreme Court of Appeal, where you'll see SCA, that's the abbreviation for Supreme Court of Appeal, if you have an outcome from there, you can use the outcome from that to come to an outcome in your magistrate's court. If your case is in Mag Court, they can use the outcome from a higher court in part of the argument in a lower court. Okay, does it make sense? All right, so that's basically your case law. Your case law also therefore forms part of the law in South Africa. Then what I do not have here is your customary law, but that also forms part of the law as long as it is not in conflict with the other laws above that. Okay, so your customary law does hold value as long as it is not in conflict with legislation or the constitution or the common law, right? And then finally, we have regulations, rules, and then lastly, your policies. So that is how policies fit into the bigger picture. Okay, any questions thus far? No? Colleagues in other venues? Any questions? No. Right, I just wanted to bring to your attention legislation. When I speak of legislation, when you look at the South African Schools Act of 1996, if you have to dissect this, basically your title, South African Schools Act, that 84 that's the 84th act that was published in that year. Okay, this could also form a nice MCQ question as well, right? That is the 84th act that was published in that year. The 1996 is the year that it was published in, or that year that it came into action. Now, just to divert a little bit, 1996 was the year that it came into action, that it could be enacted, that people could start using it. But 1996 was probably not the year that they started drafting it. So there's an entire long process that goes behind the legislation before it can come to this point, before we as common citizens can use it. It starts off first as a draft, as a bill. It needs to get signatures, it needs to go under review. They need to publish it in a public gazette. And then afterwards it gets reviewed again, and then it comes into the state. So it could take anything between a year to 5 years before it could reach to this point. Okay? Then your regulations and your rules. Okay, so a regulation, as you can see, it's subordinate legislation. What do I mean by subordinate legislation? Anybody? Subordinate, so your legislation, as I just spoke about, that is given, permission is given from Parliament, right? And ministers, okay? And that's obviously the legislation that would be used, that's the important part of it. Your regulation is then passed by authorities who have your powers to pass. So for example, I'm looking at the MEC here, okay? So it's not necessarily that the president will pass a regulation. The MEC also has the power to pass it. But the MEC will not have the power to pass a legislation, okay? So your legislation is still important, but your regulation comes after the legislation. It's a part of it. An example of this I can use would be the South African Schools Act. That is your legislation. The regulation of that, so that's passed by the government, the parliament, right? Then the MEC then from a province, from every province your MEC can make up a regulation. For example, the Schools Act is the legislation. The regulation from here can be the code of conduct or the discipline, the code of discipline in that school. So it can be a section attached to the main legislation. Your regulation is also a restriction, okay? So its function is to restrict. And I'm talking about restrictions. For example, it will give you a list of what can or cannot be done at a school. Okay? So for example, your code of conduct or your code of uniform, that can be part of a regulation because it's speaking specifically to something. It's an extension of the legislation, but it imposes more of a restriction. Right. Then your policies. So as you can see, a policy is a course of principle of action adopted or proposed by an organization or individual. How this then fits into a school environment. Who is the organization in a school environment? The principal, the governing body, right? So therefore, the principal and the governing body has the capacity to implement policies. Okay? So your policy can be made by the president or by the MEC or by the minister or senior officials like the head of department, but its job to be implemented or the guidelines to be implemented can be done by the school principal as well. Okay? So in this case, the school principal has a dual function. He is acting as an administrator of policy in terms of the head of department, as in the Department of Education, and he is also an agent from the governing body. Remember, your school principal also sits in on the governing body. So he has a dual function. He's a medium between the head of Department of Education and your school governing body. Therefore, the principal, it is so important as his task or her task to implement policies. Right. The role of a policy is to gain the vision or the aim of what the school wants. Right? Can you give me an example of a policy in a school situation? Yes, sir. Okay. Let me give you the mic. Sorry, I can't hear you from here.
The time for starting teaching, for example, the first period, and whether the period is going to be an hour or 30 minutes or 45 minutes, up to the last period. That can be written on the policy of the school.
Thank you, sir. That's a good example. Your colleague just mentioned about your schedule of a school, as in the time that it would start or at the time that it would end. Are there any other? Yes, ma'am. Admissions policy. That's also correct. As in, would you like to elaborate on that? Okay. Okay. That is a very good example. There's actually a case. I will look for that, and maybe the next time that I see you, I will discuss that case, or I'll put it up on ECI. There is a case that actually dealt with that, where there was an issue with the age requirement in a school, as well as the language policy in a school, and where there was a conflict about the medium of the language that the school would teach in. And that would actually be a good topic for discussion as well. Our colleagues from the other venues? Okay. Right. So here I spoke about organization and individual. As I said, in our next lecture and so forth, or your activities online, I will put up more stuff about policies, but this was just an introduction. From here, I said organization and individual, right? Remember when I started in the beginning of this lecture, I spoke to you and I said, we have legal rights and obligations, or legal rights and duties. But in order for us to have legal rights and duties, what do you think is the deciding factor? How does an organization or an individual gain those rights? How do you think it comes about? Common goal, she says. Okay. 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 Your colleague says the fact that you're born in a country, you have legal rights. But if you look at it in the bigger picture, how do you think it came about that it was decided as human beings we have legal rights? Okay, so legal entities and juristic entities, right? A legal entity is a person, right? A legal person basically is somebody who can enter into a contract, who can sue or can be sued, has the right to property, has legal duties, rights, and obligations. In a school environment, who can be classified as a legal person? Parents, educators, learners, they also have obligations, right? It's not that they just have rights. What are some of the obligations? To adhere to the school's code of conduct, to adhere to discipline, the school's policies. What about the educator's obligations? What do you think is an educator's obligation? If you think not too far back, when I spoke earlier about the concept of hate, an educator's obligation, primary obligation, is to provide safety and security to learners at the school. Right? Of course, your academic part of it as well, but as in that, your safety and security. So a legal entity is or a legal person, as it's there. This is in terms of section 15 of the South African Schools Act. Okay. And then a juristic entity is somebody, or not somebody, is something that has the capacity conferred on them by some unnatural process. And I have unnatural in inverted commas. It's a non-human person. This then refers to your corporations, your firms, your government agencies, universities, or public schools. Now, thus far, most of what I was speaking about, you would have to look at it in the context of a public school. Private schools can have their own policies. It still has to be in line with the Constitution, but it is not generalized. Okay? So your juristic entities in this circumstance is your public school. How does it then fit with what I just told you? This is how a school is an organization. This is how a school then has the obligation towards students, because it is a juristic entity. Coming back to the question of what I asked, how do you know that you're a legal person? How can you classify yourself as a person? I know it sounds very biological. How do you classify yourself as a person? You know you get rights, but how do you classify yourself as a person? Okay, that question was actually posed in law in one of the cases. It had to deal with a test because a lady actually planned the murder. It was actually the mistress who planned the murder of the wife's unborn child so that the child would not inherit the money. So the courts had to come up with a test to decide whether the fetus would have been alive if it was born or not. And they came up with a hydrostatic test. Okay, if you're queasy, block this out, where the unborn child, obviously it was dead because the mistress organized for the child to be, the pregnant mother to be shot in her tummy, right? So the child was obviously dead, but then the test would be that if the child was born at the time, would the child be born alive? Okay. The hydrostatic test is then where they cut a piece of the child's lung and place it in water, hence hydrostatic. And from that, they can decipher whether the lungs would or whether it would breathe or not, if it was born at that time, or if the child took its first breath after being born, right? The mother died in that instance, and therefore they had to decipher about the child. Okay, so what I'm trying to say, how does it refer back to here? That hydrostatic test is what they used to use to define whether a person is born alive. And when you're born alive, that makes you a person. And if you're a person, then you have legal rights. You have a right, but until 7 years, you do not have an obligation. Okay? It was a bit different in the past, but they changed it. Okay? So you have a right from the time you are born as an infant, but until 7 years, you do not have an obligation. Okay? Hence, there's a certain age where you still have to gain consent. Therefore, learners from school still have to get their guardian's consent. Right. So the role of policy in education is to establish and regulate the procedures, to create a safe environment, and to adhere to the legislation. Right, why I have an asterisk next to the legislation? I said all of this needs to be in line with the Constitution. If it is not, it can be challenged. Okay, we'll also have an asterisk there because at some points there's a lot of debate about whether religious factors should take preference in a school, or whether the school should set out what the medium should be, whether students should be allowed to use certain religious items to school, all of that. There's a lot of cases about that, and I'm sure a lot of you have read about it. It has been in the media. Right, are there any questions thus far? Is there anything you would like to know? So, okay. No, sure, it's interesting. It's human nature to want to find out. We have like 2 minutes. Okay, so in the end of it, the mother was dead, but the mistress could not inherit because after a while the child did die because it sustained injuries, but it was born alive. So even though it died afterwards, it was born alive. But it did not survive to benefit or enjoy the inheritance, but it was rightfully the child's. The mistress could not get to that. But it did mark a change, and that is how the hydrostatic change came. The hydrostatic whole process. Right, are there any other questions? There is a class activity that I did plan on doing at this point, but I know that you're drained and you're tired. I will put this up as a forum. Please partake in it. It will be as a forum on your ECI page. Right? It's something very simple. It's just to get I know at this point, a lot of us have a lot of opinions, and there are some things so it's very simple. It's not going to take you much time. Obviously, when you're working on ECI, you cannot work in pairs. So you would do this individually, but I will put this up on your ECI page. Thank you. Okay, our colleagues from the other centers, thank you. Are there any questions? Thank you, ladies and gentlemen. Have a lovely evening.